been translated into a visible reality. How? When you talk about the administration of justice, it should not only be limited to Freetown. If you talk about administration of justice, it entails a lot. Expeditious trials, fair trial, like Laura Rashid was saying.
Right.
And what we have done as a judiciary is to ensure we take decentralization, to take the justice system from Freetown and take it to the doorstep of every Sierra Leonean, regardless of your social status, regardless of your religious background, regardless of your political belief. What is more important to us under this current administration is that as long as you are citizen of this great nation, you deserve justice. And mark you, if you look at the constitution, the judiciary itself, many writers, including one of the most enviable and outstanding legal minds in the United States of America, he said the judiciary is more respectable among the other organs of government because the judiciary protects the rights of the citizen. They see the judiciary as their own protector when they are actually, when they feel threatened by the possible excesses of the other two organs of government, that is the legislative and the executive organs of government. The only institution to seek solace from is the judiciary. Hence, the reason why they say judiciary is more respected. Now, to answer to your question, for the very first time since independence, for us to have judges in places where there have been no sitting judges, that is to tell you that that vision in the mind of the Honorable Chief Justice has been translated into a visible reality. Today, for the very first time, we have a sitting judge in Kailam. Today, for the very first time, we have a sitting judge in Putloko. Today, for the very first time, we have a sitting judge in Putloko, among other places. Today, for the very first time since independence, we have magistrates in almost every part of Sierra Leone. That is just to tell you that the administration of justice, we are not yet there, but we are moving, even though at a very progressive pace, but very sustainable. That is why, for the very first time, today we were rated by the Project Justice Sector report. We were far ahead of Nigeria, in Pakistan, and other countries that people think that when it comes to their democratic credentials are more advanced than Sierra Leone. Now we have, for the very first time, we have specialized courts for the very first time in Sierra Leone. This is because we actually want to take the justice system not only to those Freetonians, but to take it to people across Sierra Leone.
Is that sector being politicized? Are you being influenced, the judiciary, politically? I mean, is there a hand influencing what you do, especially when it comes to political cases?
Now, we have had a situation, not only the case of Peter Conte, who is a registered member, fully paid member of the main opposition, All People's Congress. He petitioned or actually took a matter to court that was presided over by the Honorable Judge, Honorable Justice Adrian Fisher. That is just to tell you, is to send a far-reaching message that if his confidence in the judiciary remained flattened or damping, there was no need to revert to the judiciary to seek redress. This is just to tell you the magnitude of the confidence we are building. We are not there yet, but it is the progress we are making is so admirable and impressive that we are sure in the not too distant future, at the end of the day, Sierra Leone's judiciary will be enviable and match up with other judiciary, not only within the sub-region, but in advanced democracy.
Mohamed Kamarimba Mansaray is standing trial for grave offenses. I mean, we're all aware of the serious nature of the offenses he's standing trial for. And he needs to, like Honorable Ba said, he needs to go through the trial. But many people are now looking at the fact that this prolonged detention or incarceration of Mohamed Kamarimba Mansaray, what is it all about? If he's been released today, does he pose a threat to the ongoing court case? Why is he being held? Or up till now, is there a reason? I mean, what threat does it pose to the case from the judicial?
Very interesting that the issue of Kamarimba came up. And I hope those who are listening out there will actually listen attentively to actually understand the dynamics when it comes to the issue of Kamarimba.
Right.
Let me say this. Kamarimba, even though he's a politician, he is not the only person that has been detained or remanded by the judiciary or under the sexual offences model court. He's not the only person. We have dozens of Sierra Leoneans, accused persons, who were or have been refused bail for obvious reasons. Now,
spanning over a year.
That's what I am saying.
Right. Go ahead.
Now, let me, for Kamarimba's case, the judge, let me say this, the judge is not in any way averse to granting bail to Kamarimba. Unfortunately, his lawyers are not here. They have actually not been sincere.
His lawyers?
His lawyers have not been sincere when it comes to ensuring that they do the needful in terms of ensuring that bail is granted to Kamarimba. How? What does that mean?
Exactly, because I was just going to ask you.
Exactly. Let me answer. Let me answer that.
Yes.
Now, they made an application for bail to be granted. The reason adduced before the court was because of his health reason. Because to them, Kamarimba is unwell and is suffering from a very serious ailment and needs urgent medical attention overseas. That his ailment or the sickness he's suffering from is so serious that our medical facility cannot provide the required treatment for Kamarimba. The Honorable Judge, Justice Samuel Otelo, said the lawyers were not in any way the competent authorities, or they are not competent to actually diagnose the seriousness of his ailment. The only person that can decide that is a medical practitioner. Medical practitioner is the only competent authority that can tell the court with evidence that indeed the claims by Kamarimba's lawyer is indeed true, based on the diagnosis and the certificate presented to the court. What actually happened was that they tendered in a certificate, medical certificate. They said it was a medical certificate that they got from the prisons after going through careful and standard diagnosis. What they presented before the court was a photocopy of the medical certificate. The court said, for best practice evidence, you cannot bring a photocopy they expect the court to actually certify it as something authentic. Bring the original. It took almost a month argue on that, the authenticity of that particular document, whether it was authentic or not. They said they brought in photocopy certificate, medical certificate. The court said, no, this is not the original. Bring the original. They said it was original. They were arguing back and forth, not until they later told the court, admitted before the court now, that indeed it was the photocopy certificate. That they went on to tell the court that they were the medical practitioner or the doctor who is at the correctional center did not issue or did not refuse giving them the original certificate. Imagine, almost a month, at the tail end of it, they admitted. Now, coincidentally, it had coincided with the almost closure of the case of the prosecution, because the prosecution had already closed their case. So they were given two options: either a no case submission or to open their case. This is very sensitive. I know. I want to educate the public.
Yes, I know it's very sensitive, but just so as we go, we clear some doubt.
Yeah.
When they made that application on health grounds, did the state send any medical doctor?
That is where I am coming now.
Continue.
That is where I am coming.
Continue.
Now, they made an application. I'm sorry, they had an option whether to make a no-case submission or to open their case. And in opening their case, they were actually going to use those two medical practitioners I'm coming to call as witnesses.
Right.
So instead of opening their case, they went for no-case submission. So what happened? The judge made an order that they should contact the chief medical officer, the office of the chief medical officer, and ask the office of the chief medical officer to give them two medical practitioners among 5 of the most renowned medical practitioners, seasoned medical practitioners in Sierra Leone, to give out of the list of the competent medical practitioners, to give them two seasoned and most respectable medical practitioners. What happened? They brought in two medical practitioners, and it was inconclusive. The certificate also tendered was inconclusive. It was one page and a half. It was they recommended in the medical certificate that Kamarimba needs is it urologist? 2 different medical practitioners again to come and diagnose what is actually happening, what is the cause of the problem. So even the medical certificate that was tendered was inconclusive. So the state of the matter now is that they have not been able to justify the reason adduced before the court for Kamarimba to be granted bail based on medical grounds. Today,
so they did not convince the court at
exactly.
all.
Firstly, they brought in photocopy document.
And they never brought in again the original.
They did not bring the original.
Okay.
And they have been on this, on that particular, either original or not original, just a month. Asking for adjournment in just a month.
Right.
They came again. They did not go strictly by the order given to them by the honorable judge, who is Justice Samuel O. Taylor, to actually contact the office of the chief medical officer to provide seasoned medical practitioners to be able to diagnose the problem. So had they done that, The issue of medical, whether in fact their claim was so deceitful, there was no need to come here for that.
Okay.
So
I want you to hold on a bit. I'm trying to get the lead for the defense team for Mohamed Kamarianba Mansaray, Emmanuel Safa Abdullahi, to just quickly make clarification on that before I get the bite of Emmanuel. Good evening and welcome to YVN Sunday.
Good evening.
Yeah. All right. Quickly, Emmanuel. I'm talking about, I'm discussing the issue around Mohamed Kamarianba's bail denial and things like that. And according to the judiciary, you, the defense team, you've been exhibiting some form of insincerity with regards even the medical reasons you advanced for him to be granted bail. You did not convince the court, so you are insincere and misleading the public with regards granting Mohamed Kamarianba Mansaray bail. Should you have met all the requirements by the court, Mohamed Kamarianba Mansaray should be out whilst the case continues.
Well, thank you very much, Samuel. May I just get on record that I don't like doing interviews when I am doing a case because it's not professional. But when you hear something like that, it basically questions the integrity and professionalism of the defense team, and I am the lead defense counsel. So I would want to know who said this, who is saying this, actually.
The judiciary is represented by the Director of Communications, Elkas Sano, and he has the authority to speak on behalf of the judiciary with regards to the matter.
But this is quite unfortunate. I mean, because the Director of Communications, or whatever the title is not in the court on a daily basis. They've not been in that court or monitoring that court on any basis. You are not in the court, you are not the judge. I don't understand how you claim that the defense has been insincere. When from the onset, when Kamarimba went to the trial, now when he was charged to court, the defense has been making applications for bail. Now the applications for bail has been made like 100 times before his health issues came up. Now, how do you say we are insincere and we are presenting something that the judge is not satisfied with? Was it medical reasons that we advanced when he was first charged to court when we applied for bail? No. We applied for bail because it's out of right, the constitutional right. And about 6 months into that trial, we were still applying for bail without any medical reasons before his medical conditions came up. Now, if the director himself can sit on a national television and try to question people's integrity, then he is questioning the integrity of the director of medical service. Because when Kamarianba started complaining, the director of medical services of Sierra Leone, the whole nation, sent in medical doctors who went in and basically did a diagnostic test and came up with the same results. They came out with a report. This is not a private doctor of Mohamed Kamarianba Mansaray at all. The issue of bail has not been an issue that has been hidden. Every sitting in the last 10 months that we've gone, we have renewed the application. So it is really quite disappointing that, because you, as a director of communications or whatever, because the lawyers who are on the team are not there, you make such baseless and unfounded allegations. Because this is really completely untrue, and it does not even follow the pattern of that trial.
Can I quickly ask you this question? Based on your estimation, why and the efforts you've made in submitting applications for Mohamed Kamarianba Mansaray to be granted bail, all of those efforts you said have not been fruitful because the court has not yielded to granting Kamarimba's constitutional rights, right to bail. Then where does that put your confidence without going into, without any form of prejudice to the matter? Where does that put?
No, but Samuel, I don't want to talk about my confidence. I don't want to give my opinion about this trial.
Right.
I am a lawyer. I do my case in court. And
Hello? Hello? Okay, I think we have some terrible network. That we'll try and see if we can establish contact again with him. So, Elkas, Emmanuel just submitted that even before advancing the health reasons for him to be granted bail, they've made over 100 applications citing his constitutional rights to be granted bail, like Lawyer Rashid was submitting.
Now, let me re-echo this.
Yeah.
For the consumption of our public. Aside from
let
me just quickly, we'll have to round up here. Emmanuel is here again. Yes, Emmanuel, please go ahead.
Yeah, the confidence the confidence of the judiciary for me as a lawyer is very high. I expect the judiciary to do the right thing. Bail is at the discretion of the judge. The judge knows why he's not granting bail. And this is not something that is new. It is not new to Kamarimba. But we thought that because he's a high-profile person and who does not have to disappear overnight and he will give shorty, he should have been granted bail. But again, if the judge sees otherwise, we go by his ruling. But it is completely unfair, completely wrong, and it also doesn't follow journalistic professional etiquette for director of communications to be throwing words on the defense thing because you realize that they are not on the panel. I think that's not how it is done. I have been a journalist, I've been a PR person. I think it's good for you to mention the stance of the judiciary and defend it rather than questioning people's integrity. When you see people are not sincere, you are saying they are dishonest. You say they haven't been professional. And I think that is not something that comes from someone who is a professional PR person.
Thank you. Thank you very much, Emmanuel. We truly appreciate your time, and thank you.
Thank you.
All right, Elkash, you can continue.
Yes. Emmanuel Safa Abdullah was saying, aside from even the medical grounds, which is very much fundamental, that was, to them, the need.
That was the height.
That was the need. It was very urgent that Kamarimba should need urgent medical attention, that the treatment is should not have
there was the claim of him developing prostate cancer.
Exactly. So look at what happened. The order that was given by the judge was not duly followed. That is one. That aside, it is the exclusive right and unfettered discretion of the judge as provided for in the Criminal Procedure Act of 1965, like Lawyer Rashid was just saying. That is very much clear.
But when the Constitution says, I mean, it is his right to be granted bail, and the criminal procedure, so it's like Lawyer Rashid is saying, you give and you take. You give and collect back the same right. Let me have Rashid's opinion on that, just quickly. And you've listened to the submission of Elkas and that of Emmanuel Safa Abdullah, the lead defense counsel.
Yeah, it was really good that Safa came in. That was good on your part, because I was not going to talk
respond
about
to that, right.
Claims on the defense. I'm not part of his defense team. Although I have been very voicey for us regarding the issue of his rights to bail.
Yeah.
I've made it very clear that I'm not part of his defense team, and I've never entered any appearance in terms of representing him on trial. But as a human rights lawyer, I have an obligation, myself and my organization, to always speak out, not only for Kamarimba, but on many, many other issues when people's rights are infringed upon. So let's go back to the basis. And like the Cascade said, let me start first by looking perhaps at the good things, because it's also important for us to have a context.
Right.
Because again, I've had many people decry the judiciary outrightly under this regime, and I think it's unfair analysis. So I am very careful to always be an advocate that looks at the good and the bad as well as the ugly. So let's look at the good things that this judiciary has done under the tenure of the current Chief Justice. Administrative-wise, they have made a lot of improvement. So if you go to the judiciary now, the courts buildings, you will see a lot of reforms happening there. That's good. Even the division of the courts. So for the first time, we've now seen the magistrate courts moved from the Stephen building and then sent somewhere. So that's in itself has created some decorum in the entire court system. You can enter now the High Court, the Superior Court of Judicature, and you can really enjoy some sanity and decorum. To me, that was wisdom, that was very good. the setting up of the specialized courts,
Yeah.
like you rightly mentioned, we have the modern court on sexual offenses,
right.
there's anti-corruption courts, you know, and then we even have the one on the NACIT also. You know, these are unique courts, and they were necessary to be formed because so many issues, I mean, borders around them, and they have helped in many ways to expedite, you know, the judicial process. More magistrates and judges. He has recruited more magistrates and judges among, I'm sure by records, is the lead in terms of that area, and also more courts in the provinces. So we have had expansions, access to justice. These are things we have to say. It's good for the judiciary, and any other person that comes down the line will inherit this structure, and I'm sure it will make a good feather in the cap of the judiciary. But then let me run quickly to the flip side.
Right.
So what I have noticed from a human rights perspective, the wheels of justice, they are still not turning as they should. So that is the first indictment I have in this current
When you say
discussion.
the wheel is not spinning as it should be,
so
what
it's
does that
not
mean?
so much now about the administrative, the structure, the having more judges, but how fast are the wheels of justice turning? For example, now, the Kamarianba issue is one.
Right.
So we want to see a judiciary that will now ensure fundamental rights of accused person when they come before them. You know why the judiciary in South Africa is making waves? You know, look at what's happening now.
With Zuma.
Zuma is thinking that because he was a president, no. The Constitutional Court said because you did not appear for that local public hearing on the Commission of Inquiry, we found you to have acted in contempt and violated the Constitution, and therefore we order you to be in prison. This is the kind of judiciary that you will stand up and say, and you thought it was a joke. They said the more you delay, the more we might change our minds to even increase it. So go and start there now. So he has agreed today. He's now in prison.
Right.
So, and that court started from Mandela. It's not even Zuma. Mandela, the first democratically black president in South Africa. He was brought for that court, and the court found him liable. And Mandela said, I will respect the court. He had to go, he had to beg, he had to follow the orders of the court. So, and that was the beginning of making the judiciary have a say. So that's one of the things we are still grappling with. Slow in assignment of cases. There are many cases still that have not been assigned. You know, we have perhaps even the one on the COI. Remember the judiciary?
Yeah.
I mean the bar session brought a very good, you know, petition against that process, and that was not even had up to today. Perception on political influence on the judiciary, and of course,
And that is very bold.
the perception. People, if you go to if you make a perception of it,
Right.
because people are still thinking the judiciary. You know, the few judgments that came up on the parliamentarians.
Yes.
That will leave to dent the image of the judiciary to a large extent, third-party interference. And even current, as I speak to you, I'll be soon, on Monday or Tuesday, I'll be writing the DPP. I'm doing the case where the DPP has interfered. You know, it's a private case between my client is a private person bringing. My client brought the managers of Total private, you know, entity as well. Yeah, before the court on criminal, charges. I understand as I speak to you that the DPP has entered in only prosecuting and has squashed the entire proceedings. I don't understand it. The judge just told me that the case is finished. Wherever we brought the action, not the state. It's not against any government person. So that is the point. So where is the interference coming in? Third-party interference. The judiciary has to be strong enough to buffer itself and not allow these things to happen. So these are some of the things I have noted that perhaps are currently being a challenge in this dispensation. Now let's go to the issue of Kamarianba.
Yes, please.
Now, to be clear enough, we don't really, in fact, there is no, sometimes, you see, I want my courts to be so unique that it doesn't necessarily even mean all the time that people should apply for bail. When a judiciary gets to that point where the judges and the magistrates understand that this is a fundamental right that should be guaranteed, sometimes they have the unfettered discretion and also to even apply it in favor, of the accused.
But with the current status quo, like Elka submitted, this is the absolute right of the judge, because it is left with him. He has to use his discretion whether to grant bail or not.
Yes.
And that is legal according to the 1965 Criminal Procedure Act.
Yeah, but let me that's a disclaimer. Now, the judiciary realized that in 2018. Well, from 2017, 2018, they realized that this legislation is bad. So what they did, and with funding from the UNDP, they now initiated a regulation process. So we have the bail regulation.
And sentencing.
Yes.
Okay.
Yeah, so a whole framework was developed. It's a bail regulation of 2018, where they now try to define how this discretion ought to be used by the benchers. So it's an effort to now show how that discretion will be used, but then it's also not conclusive. I've read it. You can still see that discretion is still
in the hands of the...
They try to explain, okay, in this instance, if you see so and so, if you are afraid that it might run away, if you are afraid that if the seriousness of the offense, so they show circumstances in which now the judge or magistrate will tailor himself as he makes the discretion. So the bail regulation does not even help out. I was arguing the other day. Because what we really needed is to define, for example, why do we need discretion over offenses that are non-felonious? Amicus cases. Do we need to even put it there? That is bail as of right. Because you know why it is important? I will give you some reasons I've written down here. Firstly, we have to decongest our prison. There are many people who are really behind bars, who are not supposed to be there for offenses. So you put more burden on the state to feed them, and then we don't even have a proper prison condition. So there's also the case of human rights violation of their rights to health, their right to food, their right to good shelter, because these are the things. So if you know you don't have the conditions and the facilities, why refuse bail for even misdemeanors? So you know what happens now? You know what happens? Because we have this kind of bad law, people will only go to court these days on the first day. So they can charge you for a maker's case, and then they believe their lawyer can just apply or oppose bail, and then get you in the cell, and then the next day they are no longer in the court. Because to them,
they're satisfied. It's okay.
Yes, as long as they are, yeah. So the issue of the law has, in a way, incentivized malicious prosecutions in our country. That is the thing we are not understanding. Because they can be for malicious damage, abusive language, and the person can still object to bail. Because the law says, even for those offenses, the magistrates can or cannot. So you make it so easier for people to go down.
But are there not criteria laid down for the consideration of the magistrate or the judge to utilize that discretionary power given?
So here is the case. So in the bail regulation, we noticed some few situations where he could or he could not.
Okay.
So for example, if the nature of the crime, the seriousness of the charges, the flight risk potential of the accused, him interfering with the witnesses. But then here is what international law has said, and there are case law on this, that when a person is charged with any criminal offense, the right to grant bail is much more stronger than you considering other factors. That is why bail is not really setting him free. So let's also define what is bail. So bail is basically giving him a condition, all right, upon which he can be temporarily freed, all right, and be allowed
conditional freedom, so to speak.
And allow him to prepare his case to appear before the court. So bail can be tied. To me, the best way to object with this to avoid all of this hula baloo is to have granted a bail with conditions. It could be every condition. It can be shorties, it can be house condition, it could be reporting condition to say every day you must come to the judiciary and sign.
And even just confine him to the house.
Confine him to a place where he is well secured and all of these things, and then make sure. So there are many ways we could have played around this. But then to let him be in that detention up to a year now or so without the issue of bail being addressed. Now, here is the flips, here's the danger. So if it turns out that in fact he's guilty, people just say, oh, well, come on, we know from day one that that's what you wanted. So that to prevent all of that, you should have granted him bail, allowed him to enjoy his rights, and then you tidy up the process speedily, and then you get to conviction if at all the evidences clearly points out to that. So this is the thing. We don't want more for the judiciary to now be castigated that, you know what, we knew the outcome from day one.
Right.
That's why you didn't even allow him bail, because this is what you wanted. So no matter how we run away from this, it will definitely be the sentiment expressed by the public.
Right.
So how do we fight this and then make sure we mitigate and have more respect for the judiciary is to consider bail for him. Especially so now that the prosecution has closed their case. So he's now opening his case. It was a long day. Let him have the freedom to now put his defense, get his witnesses, be given that freedom to get. Look at me. There are conditions that can ensure his attendance and not even leaving his jurisdiction. The country, we have power with it. They can even guide his house.
Right.
And make sure he moves when he ought to. And then he cannot leave the place until he has permission. There are many issues to do about this, but he has to be granted that bail so that the law under the Constitution is respected.
Yes.
Yes,
with all due respect to my brother Rashid, who actually limited the issue of bail to at the discretion of our judges to only Sierra Leone. Let me make an analogy to a classical case in the UK. Julian Assange, who is the co-founder of WikiLeaks, was detained for almost 2 years, and the judge I cannot remember the judge's name. The judge refused bail, Justice Vanessa. Justice Vanessa refused granting bail even when applications were made, reasons were adduced before the court. This is a country, when we talk about advanced democracy, with international, with huge and admirable international clout, United UK. And guess what? When they were prosecuting him, United States of America made an application that he should be extradited to the United States of America. You understand? Yeah. He refused the request, and that if the United States of America wants to challenge her decision, they have every right to do so. But in the case of Julian Assange, that case is a very prominent case on the issue of bail, to tell you that the issue of bail is the exclusive right. It's not only limited to Sierra Leone, but even with countries with advanced democracies in the UK. Google it or continue after here, go and research about Julian Assange's case, was under detention for almost 2 years. And bail was refused, which means it is and continues to be the exclusive right and unfettered discretion of the judge. For us, like I stated, the judge is not in any way averse to granting him bail. But in an event wherein you said, we want bail for our client based on his health condition, and there was need to travel with him out of Sierra Leone, then the reason adduced was because we don't have that medical facility. The judge said, yes, you, the lawyers, are not competent enough to actually tell me the health condition of your client. And indeed it's true. And they referred his lawyers to the chief medical officer. And at the end of the day, how on earth, Rashid, you've practiced, how on earth can you present a photocopy certificate? And they were on that more than a month arguing for or against. And at the end of the day, they actually came and told the court that indeed it was a photocopy certificate given to us by the doctors from the correctional center. That is just one aspect.
Yeah, because I was going to say, Manuel even submitted that they've made attempts, they've made efforts, they've submitted applications for him to be granted bail before advancing the
that was that was the crux or very fundamental in actually demanding for bail. That was what they used. That was what they used. Like Emmanuel was saying, we are here to educate the public. We are not here to actually be on each other's throat. That was why I actually ignored his submission that I have not been in court. I am always, when it comes to Kamarimba's case, not only in Kamarimba's case, I am every day in court, monitoring court proceedings. Not only myself, we have our team. We have the communications now. It's a whole department. Rashid can attest to that. If I did not actually attend, I have other people who will attend. The reason why we attend, because we actually want, when you talk about access to justice, you're talking about moving the judiciary, a judiciary that people claim was shrouded in secrecy. We actually want to actually repose confidence when it comes to fair trial, to report on it. For the very first time, you will also attest that on either weekly or daily basis, that will report what happens in court. That is just to bring that is a way of bringing the judiciary to the people.
Yes.
And also present, when you talk about trial, we report both sides. We are not only reporting the part of the prosecution, we report the defense as well. Lawyer Rashid can also attest to that. We are in so many groups, you know that.
Your certainty about the enjoyment of these rights by our judges, I mean, the exclusive right of the judge or judges.
As provided for
criminal.
Yes.
So, are there no guiding principles as to how they should enjoy this exclusive right?
When the judge refuses granting a bail, there must be a reason for that.
In this case, where the reasons made known.
That's what I am saying. There must be a reason. Even before my submission, Lawyer Rashid took his time to explain that apart from the murder and other offenses he actually named, when you come to 79.2, it talks about if the court thinks it's wise, it's